All rise. Court is back in session.
Thank you. Please be seated. Yes. Thank you. On Mr. White's case?
Is those on?
He's on exam, Judge.
Oh, it said to be handled. Awesome. Judge, I think that's all I have. May I be excused?
Yes, sir. Thank you, sir. Have a great day. Have a good weekend.
You too.
How you doing? Good. Mr. White, Mr. Notes, and hopefully his audio is locking up. Okay. Not so far, it's not. I'm going to stop his video and see if that'll help on his audio. Well, he sees us. There we go. Good. Hello, Mr. Notes.
Good afternoon, Judge. How are you?
Good afternoon. Well, how are you?
Running, always.
Yes, sir. Here with Mr. White and his mom. So, what are we doing, Mr. Notes? I've got all kinds of orders, and I just read an email that came into me this morning. I think it was around 9 something from JPO Melissa Caudill. And so what are we doing on Mr. White's case? Bond hearing is what the notes say.
So, Judge, he's got 7 pending cases in 2022.
Yes, sir.
Then he had been down somewhere in South Florida and in some type of program.
Right.
And then he got back here, and there was a case 23 CF 320 that he was arrested with and went to first appearance on. And I believe out of that hearing, all of his previous bonds were then revoked on all the other 7 cases.
By Judge Stone, right.
And at first appearance, he did not receive no bonds on the new cases, on the 23 CF 320 case. And so I guess on one hand, we're trying to get a bond, the other bonds reinstated, and then this new case, we're asking the court to consider setting a reasonable bond. What I don't know that I saw somewhere that there was, it looked like the bondsman had come off of the bond in one spot. It looked like the order, and I may be wrong about that. Maybe I would hope the bondsman has not come off of the bonds, because then get them rewritten becomes a hassle for everybody.
Yes, sir.
So we're asking if the bondsman's not come off the bonds, we'd like to reinstate him and then give him a new bond on the new case number. It is in reality what we're trying to accomplish.
Okay, to the state.
Judge, there's also another case that Mr. White went through first appearance this weekend on. If you'll read through that information, you'll see that it was done as a juvenile charge at this point. It's from the same night as the 23 CF 320 case. Judge Clark actually this weekend, during that hearing, she deviated upward from the juvenile risk assessment due to public safety concerns. Mr. White was on release with an ankle monitor at the time of the latest burglaries, which didn't seem to deter him from allegedly breaking into at least 3 cars in one night, taking, among other things, a ballistic vest and a firearm. How much detail Your Honor wants me to go into. As far as the letter from JPO Caudell, I'll let Your Honor read that. Ms. Caudell was hoping to attend today, but she had another meeting already scheduled this afternoon. She thought it was 1:30 instead of 2:30, so she's unable to attend. So we supplied the court with that letter with her concerns on the case. It's not something that I think would be appropriate in discussing right now. So.
Okay. Mr. Noakes, have you seen that?
The letter that from the JPO?
Yes, sir. Good.
Yes, sir, I have.
Okay.
Your Honor,
Hold on one second.
Okay.
Mr. White, how old are you?
17.
Okay, good. Yes, ma'am.
Ms. Caudell is not supposed to be dealing with Elijah at all. Her supervisor in Pensacola, I have a letter from her, I didn't think I had to bring it, where we had I had to do a formal complaint on her, and she said, don't worry about it, they're not going to be handling Elijah anymore because of retaliation. I have evidence. Her supervisor acknowledged the proof that I had, and they got in trouble for it, her and her supervisor. So I don't know what the letter's about. I'm just adding that she's not supposed to be Elijah's JPO. That's per her supervisor in Pensacola.
Okay.
And I do have that letter.
Okay. So, Mr. Noakes, the state raises about the latest charges. Why shouldn't the court leave all the bonds are revoked because of that?
Judge, again, my client, I'm met at the jail with him, and he simply asked me to try to get the bonds reinstated. In preparing for the hearing today, I realized that the 23 case at that first appearance there had not been any bonds set. So I'm simply addressing what my client's asked me to address. I certainly understand the court's position and the state's position, but maybe Ms. White can tell us, is there anything in store for treatment-wise that maybe might help the court feel better from a public safety point of view? I don't know if there is or isn't.
Do you want to call Ms. White as a witness?
Well, I don't know what she's got to say, Judge.
Okay.
I mean, she's there standing in court. She wants to tell us what she does at this point.
Yeah, I want to save my child's life.
Yes,
So you could miraculously let him go on out and walk out the door today. He can't come home with me. That was even the case when I paid $8,000.
Yes,
It was to get him mental health treatment. He wasn't court ordered there. That's why they let him out. Children in there with worse charges than him doing crimes in there didn't get put out. Elijah needs mental health services, and at this point, it looks like the only thing I can do is get him court ordered. I don't know what more I can do.
Yes, ma'am.
I mean, I went to Meridian, I drove, I work a lot of hours. In between my patients, I drove all the way to Pensacola on Friday to try to talk to them face to face because everybody's like pushing me to this person, that person, talk to them. Well, nobody's there Friday. Go back up there Monday, and they're telling me like, you know, we're fine if it's court order. Like, get your placement, pack it done, whatever. Bridgeway hasn't done the plaque, pack it. I don't know what more I can do. You know, I can't make anybody take him. I've tried to get my ex-husband because, you know, he is supposed to provide insurance if he has it as well. So I've contacted the courts in Alabama to get that going. That's going to take a while because if he gets more insurance, then these facilities will have zero problem taking him. So right now it's a matter of they don't, you know, like payment-wise, if they can get two insurances, it's better than one.
Yes, sir.
So, and I mean, I can't, the packet has to start at Bridgeway. I can't do anything other than that. I've been down there, talked to everybody I can talk to. I mean, what more can I do? He's punished right now for having mental health episodes in there. They have locked him away, he can't come out. They have now gone to the link to take away his tablet, he can't text me. I have a big right, I got it yesterday, signed by Judge Ketchell, because I have the text on my phone where he's saying he can't take it anymore, he's going to give in to the voices. I was able to calm my child down, because there's no point, if I want to Baker at him every time he has an episode, he would be in there every day. If I'm able to calm him down, then it's fine. At this point, he can't talk to me, they got him locked away, all because he's having mental health issues. So what do you think is going to happen tomorrow or the next day? I didn't know if he was alive. I had to call the sheriff's office in there to do a welfare check. They told me they won't tell me anything about my child.
Mr. Nopes, what do you foresee? It's without, you know, having some real firm plan on if I released Mr. White. It's an easy decision for the court because of the alleged last incidences. The hand that I'm dealt is the motion to reinstate bond and then to post bond. That motion is denied, so the bonds will remain revoked. But Mr. Nopes, as far as going forward, what do you foresee happening with Mr. White?
So the state and I discussed this morning a possible offer from the state of some type of youth offender going to some type of boot camp facility. There was one issue that she and I had that I said, well, you know, let's figure out what the offer is and let me talk to my client. But then I think we've got an issue, and I believe the state was under the impression that he had just turned 18 or was turning 18 next month or this month. He doesn't turn 18 until September. And so I believe that as we try to get closer to some firm resolution, we all need to be aware that I believe there has to be a predisposition report by the department done, as well as a pre-sentencing investigation to even consider what our resolutions might be, because I believe the department has a say since he's 17.
Ms. Davis?
Just to be clear, Mr. Nopes and I have been discussing it. It's not just that we just talked about this morning. We have been discussing it and trying to work out the details of it. Now I know there's now the newest case that has to now work through of getting brought up from the juvenile system to us as well. And so Mr. Nopes, I know, needs an opportunity to look at that and decide what kind of case he has on the defense side for that. From there, Mr. Nopes and I are going to continue to talk about how we would proceed with the juvenile sentencing if we were to enter a plea before September.
Okay.
Can I say something?
I just know that everything's being recorded. If you say anything factually about your case, it can be used against you. Mr. Nopes, before Mr. White says something on the record, anything you want to tell him?
Judge, I'm just telling not to talk about any of the facts, just like the court just did. But if there is something that he believes is relevant, I certainly would like for him to be able to express that to the court.
Mr. White?
I was just going to bring up the fact that the first time I went to county last year in March, I got out on bond that was super high, and then came in front of you, and then they told me I had a warrant, and it was from some old stuff that I already even. So then they said a higher bond. It was a threat, an alleged threat that I did, I guess. And they said it's $20,000. That's already a lot there. Then that's my second bond. So now it looks worse that I've been out on 2, and then I allegedly got arrested for this. And on top of that, now that's so like, what? I don't even know what to do now at this point. Now I got to go back to jail now. what am I supposed to do?
He's confused because he'll text me and tell me, and now that he can't talk to me, what's going to happen tonight, you know? They didn't call me when he hung himself. They didn't. The children called me 24 hours later, you know? So, and they're not watching him. That's where all this started on Saturday. He got in trouble they finally let him out. They told him you're only supposed to be out for an hour. 2 hours go by, and they come, and I guess the officer assaulted him. That's what the sheriff's office determined on me. And he told him, why are you out? You were supposed to be back in your cell an hour ago. We saw you on the camera. So now, naturally, I'm upset. Why are you watching my son on the camera and not in real time? Then I was told, and this is not from just Elijah.
Okay,
you know,
but that's hearsay. Let me just stop for a second.
Mm-hmm. You can ask
Mr. White, I think it would be really good if we give you at least a concrete procedure of what's going to happen in the future where you know what's going to happen. So when's the next time, and I know this isn't the next thing that's going to happen with Mr. White as far as his case and the defense and the state, but is the next time I'm going to see Mr. White, is it May 8th, or is there an arraignment or something before that?
It's May 8th, Your Honor.
May 8th. Okay. So I'll see Mr. White no later than May 8th, which is about 3 weeks from now. But between now and then, Mr. Noakes, are you going to see Mr. White? When are you going to see him? You're going to talk to the state about those matters that you just raised, PDRs, predisposition reports, PSIs, and about possible offers from the state, youthful offender. Bring Mr. White up to speed on all the options that you've got at this point between now and then. If Mr. White wants to accept one of those offers after understanding it and you looking at the information regarding this last case, as Ms. Davis stated, you need to understand what your defenses are to that. Then we come back on the 8th, and what? We're going to trial on one of the cases. If Mr. White doesn't want to accept all those, or you've got something that Mr. White wants to accept.
I don't anticipate setting cases for trial this coming cycle. That wouldn't be my anticipation at this point.
Okay.
But I will give Mr. Noakes some leeway, at least until that September date that Mr. White then turns 18, because things do change at that point. We'll until
My
then.
concern is Mr. White, getting him from now until September.
Sure, but I can't, I want to make sure that Mr. Noakes has the opportunity, because now we're talking about 9 cases that Mr. Noakes is having to defend. So I just, I want to make sure that the state's not in a position of pushing Mr. Noakes with 9 different cases, of pushing him into a position of hurry up and go to trial.
Understand?
Your Honor, and he's never talked to Elijah about facts of the case at all. He's been on the case a year. So he's not prepared for trial.
And I'm not trying to push the trial either. That wouldn't discuss.
No, I would like to.
I'm just trying to give you some structure to know what's going on with your case. I'm not saying trying to push trial.
No, I just want to make sure my son's going to be alive. So my question is, because I was told by many attorneys that your court order people to mental health services all the time. Why can't he be in there versus jail? Like, it's not, I love my son. I don't want him home with me. I can't handle him, but I can obviously handle him better in the jail. I've never mentally abused my child or physically abused him. He acts crazy, I get a Baker Act. I mean, that's what I've done.
Yes.
I've raised my child right. Morally, he's a good person after we get through to that. I mean, you can ask Deputy Bye who works in here. He knows my son. He knows my family. I just want I shouldn't have to worry if my child is dead.
Let me answer your question. I can't make him go to mental health. I can't even say he's going to go to mental health.
But he's a juvenile. You can't order it and I make him, because I thought I could still make him. He's a child.
He's got pending felony cases against him. I just can't.
Yeah, but all the other kids at Sandy Pines did too. That's what I'm trying to ask. Like, what's the difference?
Mr. Noakes has to talk with your son, and then to the extent that your son will allow Mr. Noakes to talk to you about all the different options about mental health, pleading straight up, going to trial.
He's not going to understand that. And West Palm City is not competent. I don't trust the situation. Elijah would take any kind of plea just because he thinks he's going to say something and he's going to be like, okay, that's good, let me take it, because he's very impulsive. I brought the records in here last time just for 1 year. 7 Baker Acts he had last year for 7 months, because 5 of the months he was either in residential or in jail. 7 Baker Acts. And that was me being generous with him, because he's already told me if I did it again, he was going to kill me.
I got a question.
Mr. White.
So like, I got a hold in a different county of what, and then I don't, like, what's going on? I don't, what am I supposed to go back to the jail and just sit there wondering, not knowing what's going
Mr.
on?
Noakes,
He's not going to come talk.
is there a hold from another county?
It's in Palm Beach, Judge. He has the other, it's a vehicle theft from when he was,
He ran away.
in Palm Beach. It was supposedly, that's where, what had been represented by his mother before was that she had taken him there for a mental health facility, and that's where
He lived there, and he came home because and I made a fuss, trust and believe. I was really mad about him getting his discharge date. And he came home, and then he ran away there. So, she doesn't know the situation. It's neither here nor there. Normal people don't do things like this.
Okay. Well, Mr. Noakes, you're the one that's got the burden of pulling all this together. Talking to Mr. White about that, and Mr. White, as much as you'll let Mr. Noakes talk to your mom about the cases, he can do that. If you say he can't, it's an attorney-client relationship between you and Mr. Noakes, not your mom and Mr. Noakes.
Yeah, I know that. Do you know how long it would take to get a new if I fire him because he hasn't done anything for me? He's not going to do anything for me.
Mr. Noakes, when are you going to see Mr. White next?
Judge, I will be there either Saturday or Sunday.
Okay. So Mr. Noakes will talk to you then. After you talk to him, if you believe that he hasn't been rendering effective assistance of counsel, if you don't want him to represent you, what I have to find is ineffective assistance, then you can file something just in writing that says he hadn't come to see me for all this time, whatever the reasons are for that.
Pencil, I don't got to pay for nothing.
They
That's
won't
what
let
y'all
him
don't
do it.
understand.
They won't let him mail. They won't let him talk to his attorney in West Palm
I'm
Beach.
in debt, and I can't. I don't eat nothing but 3 meals a day. Like, this is not no way to live. And y'all just don't, and y'all come here and y'all don't understand that. Y'all don't understand what I have to go back to right now. Y'all get to go home.
He should be in jail. If he makes bad decisions, even though he's not with it, I've always punished my kids because he knows. He doesn't necessarily know better, but one day when he's right, he's gonna know. But it's not just being in jail and being punished. They came into his cell the other day to antagonize him because I questioned why they're not
Judge,
watching my child.
I'm going to object at this point. We're way too far into the hearsay.
Anyway, I can give you the evidence on the text, but we have a Baker
Hold on,
Act
Ms.
right
White.
now, so we're gonna do the same thing and not honor it.
Okay, Mr. White, I'll see you back here no later than May 8th.
All right.
And Mr. Noakes will come see you this week.
All right, sir.
Thank you, sir.
So what about the Baker Act? It's the same thing? Nobody's gonna
We need to
pick 'em up?
file that paperwork. It's got to go through its own system.
It is. It's been filed. So then what? We do the same thing, we just don't pick them up?
If Baker Act finds there's probable cause.
It is. So what, that's what I'm asking, what now?
Judge, the jail will not transport on the Baker Act. I've had that conversation last summer.
Of policy over a court order. That's what I'm asking. I want it on record again. So when he's dead, I have a lot of money. And that's not what I want. Like, I don't know, but more people can understand. She's got children. Y'all got children. You can't understand. I want my son alive. The damage that he's going through in there is going to make, he's not going to be able to work. Who's going to support my child the rest of his life? Me. That's not fair. I've raised my kids and other kids in this community. I got a good name in the community. And that's why now, they thought I got to start, I'm getting started now. Like, I have not been outspoken like I need to be, and I am now. So, just be ready. All right, thank you. So no court, we can't court order him to treatment unless he does it.
The judge that finds probable cause for the Baker Act.
That was canceled?
If they won't honor that, and there've certainly been underlying thoughts where they haven't, where the jail has not done that in the past. Mr. Noakes, if you're representing Mr. White in relation to that, and you want to file a motion for me to require the jail to transport for that, we've done some things on that. I'll make a note for me to look back at my notes at what I've done in the past. It's a really difficult situation.
I know, and right now I'm not 100% scared. Like, I'm not like, oh my God, he's going to die like I was last year. But with him not being able to communicate with me, I'm the only reason he hasn't done anything. And do you not understand that? And they're punishing him for running around himself naked?
Judge, we've addressed
She
this
just
already
sighed, so why is she
Hold on,
talking?
hold
She
on.
just sighed while I was talking. So she doesn't want to be in it, so why is she talking now?
We've already addressed this with Mr. White specifically, previously, about the Baker Act and how the sheriff's office is not going to transport. So we have already addressed this issue, Judge, and it has already been looked into by the court.
A policy, remember? It's their policy versus a court order. And come on now, my mom was a social studies teacher, she taught me civics, but I don't know that
All
much.
right, ma'am, you're done.
Okay.
Thank
Am
you.
I done, Judge Brown?
Ma'am, yes, ma'am.
Okay, thank you, Judge Brown.
I did not do I have no idea who's next.
Ma'am,
I have no idea who's next
Okay.
and anything, so that's up to,
as far as shortest to longest, do you have an idea of how you want to, Ms. Davis, are you leaving?
I am leaving.
Okay, thank you.
Judge,
Yes, Mr. Notes, you don't have any more cases this afternoon, correct?
thank you, Judge.
Thank you, sir. Okay, anybody, Mr. Switek, going to appear via Zoom? No. Okay, so I'm going to stop that. It's at 2:57. Mr. Switek, you ready?
Yes, sir.
Do we need probation here anymore?
It's a sentencing.
Yep, I think so. Yes, sir.
whoever you have.
So that's what it is?
I think it was, she made a motion. I don't know, I think they, this is what it's, that she's trying to ask for a VOP. But then I think, it's hard to tell them what she's saying.
And I can't.
And you just go in and grab the chairs that were that.
Okay. And to those of you that are here for Marjorie Vaughn, I was trying to wait a little bit to see if her attorney gets here, Ms. Jaquith.
Judge, my understanding, this is a case that Ms. Vaughn has a current warrant for. And I don't think Ms. Jacob currently represents her. I'm not sure why the clerk's office would have
Are you Ms. Vaughn?
pro se.
Okay, come on up, Ms. Vaughn.
Well, she's actually here.
Ms. Vaughn's,
I did not have
it's 22 CF 77. Good, come on up, Ms. Vaughn. So, Ms. Vaughn, you were added to my docket, so I didn't do any homework regarding your case, so why are we here?
I had written you a letter prior to the VOP, and that's why I'm asking you for a signature bond so I could take care of
Okay.
the classes. And so I turned myself in yesterday, and I did have a signature bond.
Okay, let me pull up.
I know the case number.
Hold on one second. Let me make sure that I didn't put it. 7, 9. Yes, ma'am, that's fine.
Yes.
So I've got pro se motion for bond. I did see your motion, talking about your financial hardship.
Yes.
Continue with the treatment. If you'll raise your right hand.
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, so tell me first off, what are you asking for the court to do? What's the relief? And then if you'll tell me the facts, why?
Well, I thought since I was having a VOP, it was just, I couldn't complete the DUI because I didn't have the money. I was getting evicted. It's just been so hard. And then I filed for Social Security. I think I made copies. Do you have the copies? I have some with me now too. So I just wanted a bond and a chance, or have more time, so I can just complete the DUI school and the 50 hours.
You keep talking about a bond, but there's no more or anything
Well,
else?
I'm waiting for someone to get back to me.
This was prior. Here's my
I had no
paperwork.
warrant.
Okay, hold on one second.
The warrant was generated yesterday and was sent to the sheriff's office yesterday, so she's checking it.
Yes.
Okay, good. So I'm trying to figure out
I'm
bond
sorry.
and then talking about extended
Well,
probation.
I have a court date May 18th now.
Okay.
I thought that I was going to have to sit in jail and all that and not be able to take care of my,
Well, if they say there's an outstanding warrant, you still may have that.
It was served on the 11th.
Okay, great. So you've already dealt with that?
yes, sir. So I have
And
a
you're
court,
out on your bond or whatever at this point?
Yes,
Yeah.
sir.
Okay, so we don't worry about a bond.
no, sir.
Okay. So now you're basically asking for an extension of your probation where you can do these other terms.
Yes, sir.
Okay, how long do you want to extend it?
Like I said, I have a court date May 18th, and I guess I just need at least 6 months. Like,
Okay.
I can continue with extra probation, that's okay.
So
And a
if I
payment plan.
synthesize it the way that I would want if I was you is that you'd ask to modify your supervision to extend it with the exact same terms, except extend it for 6 months. However, if you successfully completed all the terms of your supervision prior to that 6 months, then your supervision would automatically terminate. Is that what you're seeking?
Yes, sir, I'm just seeking more, I just need more time for the money.
To the
It's all
state
money
Or
issues.
probation? Is probation?
Yes, sir.
Her,
Hi, Ms. King.
in-state probation, her probation is due to term on 5/7/23. So she's not past term yet.
Right.
Right, and I praise you for coming sooner than later.
Yes, sir. I am getting transferred my probation to, I put back to Miss, yes, ma'am, on
So
Tuesday.
she still has enough time that we could extend it for 6 months? Is there anything that prevents the court from doing that?
No, sir.
Okay,
Because, see, I was gonna start a payment plan.
Yes, ma'am.
And that's why, so if I can get a payment plan started, that way that won't be violated.
right.
And I can, make a payment.
Yes, ma'am.
Like
To the
that.
state?
And
Any
just-
objection to that?
Judge, we would have no objection to that. We would know it looks like this was down to misdemeanor, but I would caution you that if you don't get those things done, probation's recommendation is to revoke and terminate with some jail time. So
Yes.
make sure you get it done.
Yes, ma'am. It was just, I couldn't set up the appointment for the DUI class because it's scheduled too, because if you don't show up,
Okay,
they take
let me
that
stop you. I
money.
don't want you to say, I don't want you to keep talking and talk yourself out of a victory, okay?
Okay.
So your motion to extend your supervision for 6 months is granted.
Thank you, sir.
The original terms and conditions, if you successfully complete all the terms of your supervision prior to that 6 months, then your supervision will automatically terminate, okay?
Yes, sir.
Thank
So,
you.
but if I set the payment plan, so do I have to have that $1,600 paid off within that 6 month period?
Yes, ma'am.
Okay.
And talk to probation if there's something else that they would recommend. If you get down and you pay that down to some amount,
Yes, sir.
and probation comes back and says, we recommend she's paid this, that the balance of this goes to collection or goes to something else,
Yes, sir.
then I'll sure look at it. We'll have another hearing. But again, thank you so much for coming to the court before there was something out against you.
Yes, sir. Thank you for
Thank you,
accepting my letter.
Yes,
I
ma'am.
appreciate it.
You're welcome.
Sir, do I still show up May 18th?
You do not need to show up on May 18th if you'll just talk to probation before you leave.
Yes, sir. Thank you so much.
Thank you.
Thank you.
Okay, Mr. Schweitzer.
Good afternoon, Your Honor.
Good afternoon, sir.
Your Honor, I'm here for two cases today for sentencing Draven Cederberg and Taylor Newman.
Yes, sir.
I think Mr. Cederberg would be shorter if we could call his case first.
Okay, yes, sir.
It's 22 CF 539.
Yes, sir. And what I read through doing my homework was your April 11th letter. The letters that were attached to that, the state's April 6th letter, the score sheet. I've got a copy of what was attached to the police report as on February 21st, 2022. Also, the first page of an arrest report, February 21st, 2022. That's the same date, but it's in two different, let's see if it's the same facts. They're different facts. I've got one that is the report date was February 21st of 22, and the other one is from the arrest report, which was dated February 21st of 22. Okay. They seem to be that the facts are stated a little differently in those two.
Right, there should have been filed, and I thought it sent to your office, but at least it was filed with the clerk. Notice of confidential filing with Dr. Holmes's report.
Okay, I did see your confidential filing, but let me see about.
The 2-page letter, yeah.
That's, yes. Heather Holmes' report that's dated March 12th. Yes, sir, I did read through that.
And Your Honor, did you have an opportunity to review, I believe there should have been some chats that were attached?
I did read through those texts. Yes, ma'am. I have notes from when I did my homework, and I didn't print all those off, but I did make notes from that.
Thank you, Judge.
Mr. Schweitzer.
Your Honor, I would move the letters and report into evidence.
Any objection?
No objection.
Okay. They're admitted, and they're the ones that are filed with the clerk, because I think I've highlighted what I printed off, but those are admitted. Okay. So those were attached to Mr. Schweitek's April 11th letter. Was the report also attached to that letter?
The report was a separate filing.
Okay, then that is also admitted.
I don't have that.
You don't have the report?
It's on the clerk's docket in the second entry to the top.
The psychological evaluation.
Yes.
Thank you. Yes, sir.
Mr. Switek, there was something besides your letter to the court and besides the two-page letter from Dr. Holmes? Or is that?
There were some letters.
Okay.
Right.
Okay.
David Blair,
Offered as
Colleen Blair,
Okay.
Kenny McDonald. Yes, ma'am. Okay. Yes, sir.
Your Honor, if I could call Mr. Cederberg, Mr. Brian Cederberg.
Okay. Mr. Brian Cederberg, if you'll please come to the stand.
Do you swear or affirm under testimony you're not to be able to do the truth, the whole truth, and nothing but the truth?
I did.
Good afternoon, sir. Could you identify yourself by stating and spelling your name?
Brian Donald Cederberg, BRIAN-DONALD-SETTERBERG.
Okay. And are you related to Draven Cederberg?
Yes, he is my nephew.
And it's my understanding, am I correct, that Draven Cederberg resides with you?
Yes, he does.
And that's here in Fort Walton Beach?
In Fort Walton, yes.
Okay. Over in Kenwood?
In Kenwood, on Country Club.
And he's doing work in that area?
He is currently working at McDonald's at night.
Okay. But he's worked for neighbors in that neighborhood doing yard work and things like that?
Yeah, he's worked for Kenny McDowell, which is actually in Elliott Point. Several times, helps him out quite a bit.
long has Draven lived with you?
About 2 years, maybe a little bit longer.
Okay, so maybe a year before the offense that he's
Yes.
entered a plea to?
Yes.
Okay. And are you familiar with his upbringing?
A little bit, yes.
Okay. If you can enlighten the court, remembering the court doesn't know anything about that, so if you could tell them what you know. Tell Judge Brownlee.
Yeah, his upbringing, his mom really kind of neglected him growing up, didn't give him good nutritious food, and basically left him on his own. Even when he went to school, he was on his own. He had to fend for himself.
And what age was that?
That's from 5 on, really, until my brother divorced his mom. So, yeah, very disruptive household, I think. She spent more time with her daughter than with her son.
Okay, and when you say disruptive household, could you describe that, please?
They drank, they did drugs, you know, it was just the way it was up there.
All right, when you say they, is that your brother and your sister-in-law?
Yes, my brother and Draven's mom.
Okay, and what are their names?
Bruce Allen Cederberg and Terry, I think still Cederberg, I'm not sure. And then my brother remarried at some point.
Okay. After the divorce, where did Draven live?
I assumed that he lived with my brother, but from reading from what Draven said to the psychologist, he actually lived with his mom for a while. So, but I was not aware of that, and I don't know if my parents were even aware of that at the time. So, then my brother remarried, and to start with, Jennifer was a nice person, and then over years she just turned abusive, you know, towards Draven and really towards the rest of the family.
Okay. So Jennifer is your brother's second wife, and Draven's
My brother's current wife.
Current
I'm not
wife.
sure
They may have
how
been-
many number of those are. So,
All right. But she's Draven's stepmother and helped raise
she
him.
is the current stepmother, yes.
Okay. What do you know about that relationship?
She too was involved with alcohol and drugs, more drugs probably than alcohol. But for what I have been told, Draven would hurt himself and then get pain pills, and she would take them and use them for herself, you know. And my dad, or his dad, my brother, worked all the time, so he was never there, so he didn't know what was going on. But I have talked to my brother over the phone, and I could hear Jennifer yelling at Draven for doing something stupid. I mean, I think it was abuse, you know. And I know from visiting up there, you know, Jennifer would yell out of the trailer and ask Draven to do something, and if he didn't do it right away, I mean, on several occasions I saw Bruce almost knock him out of the bed of a truck for not doing what you said. So it was a very abusive upbringing.
Okay. Tell me about that incident where he almost knocked him out of the truck. What happened?
Yeah, we were, my brother and I were doing some construction outside, doing something, and we took a break, and Draven was in the bed of the truck, and Jennifer yelled out of the house or something. And
How old was Draven at the time?
I want to say still in elementary school, maybe a little bit older, but not too much older.
Okay.
And he just reached up and just like hit him, you know.
Forcefully.
Forcefully, yes.
Okay. Do you know anything about Draven's mental health conditions?
I really don't, you know, other than what he has told me, you know, but being down here in Florida and them living up in North Carolina, I only saw them at the most twice a year, and most of the time it was just at Thanksgiving. So.
When Draven moved down here, were you aware that he was on prescription medication and he wasn't taking it?
I was not. I know he has a hurt shoulder, and I kept on asking him when he's going to go have that checked out, and he goes, well, I got to get insurance first. So that was a big thing, and he just informed me last week or so that he'll get insurance with McDonald's, but he's got to be there a year. So he's got a ways to go to get that. So.
Okay. Have you observed any mental health conditions that concern you with Draven?
To keep to himself all the time. I mean, he's got that whole house to do whatever he wants in it, and most of the time he stays in his bedroom. And I live by myself other than Draven.
What would you like Judge Brown to know about Draven prior to Judge Brown passing sentence?
I think he, for the most part, I mean, he's a good kid. I mean, I know he's an adult, you know, but I think if he gets back on his meds, I think this goes away. I mean, he'll start thinking clearly and everything else. I mean, I think that's the big thing. I mean, my parents have left him money to go to school on, so we have money for him to go to Northwest State College or UWF or vocational school or something. So we have money for that.
Are you aware of Draven entering a plea to the bench?
Yes, I am.
Okay. And do you understand what that is?
The judge gets to decide how this is resolved.
Okay. And you realize there's a 10-year cap in place?
Yes, I do.
Okay, those are the questions that I have for you, Mr. Cederberg, but the state attorney may have some.
I don't have any for you.
Thank you, Mr. Cederberg. You can step down. Thank you, sir. Yes, sir.
I called Draven Cederberg.
Mr. Cederberg, please come to the stand. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Yes, sir. Please be seated if you'll speak in the microphone.
Thank you.
Mr. Schweitzer.
Thank you, Judge. Okay, Mr. Cederberg, and I was talking with your uncle about entering a plea to the bench. What does that mean to you?
A plea to the bench means that, just as my uncle had said, everything in regards to my court case is decided by the judge.
Okay. And if I can get you to pull that microphone up a little bit.
Is that better?
Yes, I think so. When you entered that plea, in essence, were you taking responsibility for the offenses that you've been charged with?
Yes, sir.
And explain to me what that means.
Because of my actions, no matter what help I get or what opposition I get, everything is going to be up to the judge, and I feel as though Judge Brown would be a good source to judge me openly about the things that I have done, about the things I'm accused of, and the things that I could have done, and whether he thinks that I am not worth the time or effort for rehabilitation, I would understand that, but I would hope that I could convince him and anyone else that I've made a mistake, and I really could have hurt someone that did not deserve it.
What do you mean by rehabilitation? What do you think the court should do?
I wish to go to therapy. Whether that's after I get out of prison or not, I still want to go through therapy so I could, after all this is said and done, try to become a better person.
Okay. It's my understanding, and we've had discussions, and Dr. Holmes and I have had discussions, that at some point in your lifetime, you were prescribed certain medications. Can you tell me what they were?
Yes, sir. I was prescribed a handful of medications, about 5. The 3 that I remember was trazodone, clonazepam, and bupropion. I do not remember the names of the other 2, though. I apologize.
Okay. And from what age were you prescribed these?
Around 11 or 12 years old. I did not get trazodone, or no. I did not get trazodone until I was in college at 18. Bupropion and the other 2 I was prescribed around 13 or 14.
Do you know what those prescriptions were for?
I was told that they were for depression as well as bipolar issues.
And now that you've touched on it, where did you go to college?
I went to college at Barton College up in North Carolina.
Okay, and how far did you get?
I got 3 years, and I was almost close to finishing my 4th.
In what field were you studying?
Nursing.
Okay. And where did you go to high school?
West Johnson High School.
And where is that?
It is up in North Carolina, specifically Benson County.
Okay. And how were your grades? Were you a good student?
Through high school, I had straight A's, but eventually it began to fall off once I had gotten to college.
Okay. And do you know why?
I had personal issues at home that I had to deal with every day and every night, while also being 2 hours away at my college. I would frequently have to call home or even figure out a way to commute home on the weekends just so I could deal with family issues.
Okay. And this may be hard for you, but what issues are you talking about?
Say that once more.
This may be difficult for you to answer. What issues are you talking about?
My father was, and I assume still is, a rampant alcoholic. And my stepmother was a behemoth pill user. She was constantly doing pills, mine, my father's, and her own. So almost every night I would have to call and mediate between who took whose pills, who's been drinking, why they shouldn't start fist fighting each other, and why I need to focus on my schoolwork, but only to be told that family is more important.
I understand there was more than just physical abuse that you endured at the hands of your stepmother. Could you tell me what was going on with your stepmother?
My stepmother was very manipulative and hands-on constantly. Of course, she was physically abusive, but she would also, like, if my father ever left the house, I would have to sleep in the same bed as her because she didn't like sleeping alone. And despite having voiced my opposition from this, she would always, like, brush it off. At one point, I remember her saying something along the lines of, specifically, "Why do you care? It's not like I'm going to rape you or anything." and I was about 12 or 13.
When did that begin? Same age?
I believe that she married my father around when I was 8 years old, and from 9 onwards, it had been like that.
Okay. And continuing to what age?
Even when I was 22, she was still, if I was in the house, she wanted me to be in the same room as her, as close as possible, which is why I eventually moved out to the little barn in our front yard.
Going back to the medications, at some point you stopped taking those medications, is that correct?
Yes, sir.
And was that when you moved down here?
Yes, sir.
And why did you stop taking them?
I had a stockpile of medications that I had been using, and I'd also had some prescriptions left over. Once I had come down here, the little bit of prescriptions that I had left over, plus I couldn't get the prescription filled down here, plus lack of insurance, meant that I was basically having to stop taking the medication.
Okay. So you couldn't afford the medication?
I could not afford it, no, sir. Without insurance, it came out, even with insurance, it was about $350.
Okay. And when did that happen?
When did I stop?
Yeah.
Or
when did you, go ahead.
Around the middle of 2020.
And the offense that you're charged with, the offenses you're charged with, when did those occur?
When did my charges occur?
Yeah.
February 21st, 2022.
Okay. Those prescriptions were for depression and bipolar.
Yes, sir.
Did you notice a change in your behaviors when you stopped taking the medications?
Yes, sir.
Could you describe that to the court?
I had realized that once I had stopped taking my medication, it about a month or two after I stopped, it was a little blurry. It's like whenever if you have like a drink or a shot or something like that, you start to get a buzz feeling. That's kind of what my brain is at all times. And the medication I was taking was helping to clear it and make the smile I put on less forced.
I'm sorry, can you repeat that?
That I said make the smile that I put on less forced, where it was easier to think and be happy and things like that. I'd stop bouncing around, and ever since I had stopped taking them, that had returned to how it was before.
Do you believe not taking the medication changed your behaviors in general?
Yes, sir.
Could you describe that?
The medicine, the pills that I was taking did help me to think clearly, or at least as clear as I could. Without them, my brain is just a complete jumbled mess. Thoughts are constantly racing, muddled thoughts. If I was on those medications, I know this wouldn't have happened. And I know a lot of things would have been different if I had just stayed on those medications. But I did not, and I could not.
It was financially impossible.
Financially impossible, yes, sir.
Do you know, and you may not know, I don't know, what do those medications cost?
What do they cost?
Yeah. If you're private pay.
If I'm like paying on my own?
Yes.
I couldn't hazard a guess, but I know it'd have to be over $350.
Okay.
Considerably over, because I was taking 5 different medications.
What steps have you taken to get back on your medications?
So I had been trying to get my insurance through work in hopes that I could at least get to a doctor and start the process. But as it turned out, it was going to take a year. So in the last month, I've been trying to get Blue Cross and Blue Shield and Medicare. I had tried previously with Medicare but didn't get a response. This was a little low for before the incident had occurred.
Okay. Did you go down to the Department of Children and Families to do that, or?
No, I was doing stuff online through websites. I was trying to find different insurances that would work.
Okay. What would you like Judge Brown to know before he passes sentence? Is there anything that we haven't touched on you think is relevant?
I'm sorry. That's all I have. I'm sorry. I don't have anything, no, sir.
Okay. But you would go back to therapy and you would go back on your medications?
Gladly.
Okay. All right.
To the state.
I don't have any questions.
Thank you. Thank you, sir. Mr. Switek, any other evidence?
No other evidence.
To the state, any evidence?
No, Your Honor. We would just introduce the report and chats, I believe, through stipulation.
I have previously stipulated for that.
And you were saying the report is the same one that you entered?
No, we had conversations about whether she would have to call officers as a predicate to enter in reports, and I said to be fine with that.
Okay, so the arrest report.
And the chats, basically, the back pieces of my letter.
Everything was attached in the April 6th letter?
Yes, Your Honor.
Okay.
Right.
Those are all admitted.
State has no further evidence, only argument.
Okay. Mr. Switek, argument?
Yes, sir. Your Honor, I'm not going to go much beyond what Dr. Holmes has recommended and observed, and I think the testimony here today backs up everything that's in her letter to the court. And she notes that his actions were committed while he was isolated and without medication for a major mental illness, that he was unable to afford his medications, and that is why he wasn't taking them during the relevant time period. Dr. Holmes recommends that Mr. Cederberg seek out a psychiatrist to get current on medications, that he seek out Medicaid to re-prescribe those medications, to fill those, and then to participate in individual therapy. She also recommends, as will be the case in the next case, that these type of offenders particularly do well in group therapy as well. There's an accountability there from the other participants that's not present during individualized sessions. We think we meet the criteria for specialized treatment for a mental disorder, in particular generalized anxiety disorder, major depression, and bipolar. Mr. Cederberg has testified that he's willing to participate in therapy and that he's willing to go back on his prescription medications. And so we'd ask for a downward departure for probation and fulfilling those requirements. recommendations of myself and Dr. Holmes. In the event the court is not inclined to issue a probationary sentence, there's one thing I want to get on the record, that the low end of the guidelines, I believe, was 42 months. Is that correct?
That's correct.
And there's a 10-year cap. Without that 10-year cap, there was a 20-year statutory maximum. I have, and I want to preserve for the record, some 14th Amendment concerns with that sentencing scheme. In the federal system, if it's 28 U.S.C. section 922, excuse me, 994. In the federal system, it's prohibited to go above 25% of the minimum base guideline sentence. So in the federal system, if it was 42 months as it is here, a federal court could go up to 10.6 months in addition to that. So a little bit over 52 months. Anyway, I just wanted to get that into the record.
Yes, sir.
And that's my recommendation to the court.
Thank you. Yes, ma'am. Ms. Barrett?
Thank you, Judge. Judge, we are asking the court to adjudicate the defendant guilty and sentence him to 10 years in the Department of Corrections, followed by 5 years of sex offender probation. Mr. Switek already went over the score sheet and some of the guidelines. And while we are not required to give aggravating factors, he did bring up a good point. State would consider the nature of these chats and the very young age of the alleged child as reasons that we are asking for a sentence that is so far above the guidelines in this particular case. This defendant conversed with an undercover officer posing as the father of Tawny, an 11-year-old child. He then traveled to meet that minor to engage in sexual conduct with her. These conversations took place between February 19th and February 21st on the Whisper application over multiple days, so this defendant had plenty of time to think about what he was doing. These chats were extremely explicit in nature about what he wanted to do to the child. When the subject of having sex with the 11-year-old was broached, his immediate response was, "You would let me fuck your 11-year-old daughter? Deal. I'll accept. Cream pie or no. That's exactly what I want. When can I start?" Defense is asking for downward departure today based on specialized treatment for a mental disorder unrelated to substance abuse or addiction, and that the defendant is amenable to that treatment. And the court's well aware that downward departures are a two-step process. First, whether the court can depart, that is, whether there's been legally sufficient evidence presented in order to downward depart, and secondly, whether the court should depart. The first thing defense must show for this particular basis is the existence of a mental health diagnosis by competent, credible evidence. And there was a 2-page letter that was submitted by Heather Holmes in this case. While it says he was diagnosed with a major depressive disorder and eventually bipolar, it doesn't provide any basis for the diagnosis. It doesn't say who made the diagnosis, when, how they arrived at that conclusion. The letter doesn't indicate what reports, if any, she reviewed or any tests that she conducted. It essentially is a letter saying she talked to the defendant and his uncle. We would contrast this 2-page letter with a 9-page evaluation filed by the same doctor in another case before the court today that has an examination procedure, clinical interview, a mental status examination, 4 different tests she administered, and collateral interviews. So based on the 4 corners of the letter, we don't believe there's competent, credible evidence of a mental health diagnosis. But the second prong the defense must prove is the need for specialized treatment. And within that letter, I didn't see any sort of opinion or evidence that he requires specialized treatment unrelated to substance abuse. The last paragraph does reference a recommendation that he seek out a referral for individual therapy and get his medications re-prescribed. But there's no mention of what kind of therapy or medications he would need, or what was previously taken by him or why. And if defense is saying that this is their recommended treatment plan for purposes of downward departure, state would submit that it's not specialized and that there hasn't been a demonstrated need for it. The third prong is to show that the defendant is amenable to treatment. And amenable does not just mean that the defendant said he's willing to go. Now, there is a sentence within her letter that makes the broad assertion he's amenable to therapy and medication. But again, it doesn't say what kind of meds, what kind of individualized therapy would be beneficial. It doesn't say what symptoms they're seeking to manage or whether it's likely to change his behavior. So we don't believe defense has met their burden for downward departure on this basis. Specifically to prove with competent, credible evidence that there's an existence of a mental health disorder, that there's a necessity for specialized treatment, and a demonstration of his amenability thereof. Now, there's been a lot said about the defendant's past today, but we are asking the court to review the defendant's specific actions that brought him before Your Honor. There is no question that he has shown a sexual interest in young children. He solicited the father of an 11-year-old for sex with her and then took it one step further and traveled in an attempt to meet up with her. Defense claims that he has bipolar and depression based on the letter from Heather Holmes. However, those do not affect an ability to understand that soliciting and traveling to have sex with an 11-year-old child is wrong. And his actions within the chats have shown that he knows that. He sent a message saying, "I'm super fucking nervous about this. It'll take one choice for my life to be ruined." He goes on to say, "Big risk, big reward." This shows consciousness of guilt. And I know the court sees these traveling and soliciting undercover cases with some frequency. But in this particular instance, I want to stress that we are talking about a very young child. And he was provided several photographs in this particular case. This is who he thought he was coming to meet. He was well aware of how young this child was, and he asked if he should bring a stuffed animal for when they meet. Whether that would be to pacify her, or later he jokes he plans on stuffing her. He also makes comments including, "I'm surprisingly new to fucking kids. Just been a want for a very long time." Draven Cederberg has a demonstrated interest in children, and he is a danger to the community. So for these reasons and those outlined in our letter, we are asking you to sentence him to 10 years in the Department of Corrections, followed by 5 years of sex offender probation, with the other conditions previously outlined.
Thank you. Mr. Switek, before I ask for your final comments, the connection or lack of connection between not taking the medications and the actions that your client took that he's charged for. Is there anything in Dr. Holmes' report that says if he would have been on these meds, he wouldn't have done this?
Your Honor, I'm sure the court is aware, and I'm sure Ms. Barickman is aware, should be, that Dr. Holmes is not qualified as a forensic psychologist at PSYG to make determinations of what medications are necessary and at what level or anything along the line of a medical analysis. What she can do is say, send him to a psychiatrist to get the medications correct, which is what she said.
Okay, thank you. Your final closing argument or rebuttal?
That is it.
Okay. Mr. Cederberg, sentencing someone is just, if it's not the toughest part of this job, it's got to tie it, whatever that is. But sentencing's, the legislature gives us score sheets, but otherwise there's just a lot of leeway and discretion with the court. Before I went on the bench and when I was practicing law, and I didn't do criminal work, I did civil work, but I would say There's nobody as powerful as a circuit judge. Because if a circuit judge makes findings of fact, it's really hard to overturn that. So the power of a circuit judge, the discretion, the obligation, the duty, all those things are just huge. And I understand that. And that's why I do my homework. That's why I listen to everything, because I make the best decision that I can. When I was doing my homework, the one note, I made highlights of different things, but the one note that I made on Mr. Switek's letter I hand wrote is I put, defendant traveled to meet a, quote, minor, close quote. And I did read through all those things that the state set forth, the statements that were made by you, and that made a big impression on me also. The court does find that there's no competent, substantial, or credible evidence for a downward departure. Even if I did, I find that the court should not downwardly depart because of the facts of the case. I think about sentencing you to what's in the score sheet, or 5 years, because of your upbringing, but I don't have enough expertise from an expert. I don't have enough evidence from an expert that says, because of those things, that's why you committed this crime. Therefore, you're adjudicated guilty. You're sentenced to 10 years with the Department of Corrections with credit for all time served. That's followed by 5 years of sex offender probation. When you're released, you'll be on a GPS monitor for that 5 years. You're designated as a sexual offender. All the statutory requirements are required. Complete sex offender treatment, provide DNA sample, comply with all statutory registration requirements, no contact with any minors, no electronic equipment or computers with internet connection capability. Any devices are forfeited. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. When you're on probation, you'll have a curfew from 10 p.m. to 6 a.m. However, probation can adjust that for work purposes. Mr. Cederberg, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
My appellant rights?
Yes, sir. Meaning that if you think that I did something wrong, and Mr. Switek will give you advice on this, and you want to appeal my sentence of you, you can take it up to a higher court, but you have to do it in writing, and you have to do it within 30 days from today. Okay?
Yes, sir.
Thank you, sir. So they'll take you into custody today.
That's imbalance file notice.
Your Honor, for purposes of breaking down the counts, I believe count 1 is a second-degree felony, so I might suggest that count 2, which is a third-degree felony, would just be 5 years of sex offender probation concurrent with count 1.
Give me a range. So count 2 and 3 years, 5 years was sex offender probation, consecutive to count 1, which would be the 10 years DOC.
Count 3 was dismissed in exchange for the plea. There's just the traveling and the solicitation.
Okay, so
I do not have any. Yeah.
Would you mind if I give him my suit
Did
stuff?
you want to have a copy of the score sheet? Give me your jacket.
Yes, ma'am, I've got
Okay.
one. Yes, like this.
Oh, yes, you got it.
I have that.
Giving it to him?
Yes, ma'am.
You're good. Right here.
Back.
And his watch.
Can you scan them without using the back?
I won't stand back now.
I think that's it. Yes, sir.
And Ms. Bergman, I will put this score sheet.
Mr. Switek, are you ready on Newman?
Yes, sir.
And I put your score sheet.
Yes, ma'am. Thank you. Oh, I've got one and I signed it.
Oh, okay.
If you want to make sure the final
Yeah,
score
I
is
know
this.
this. Heather did. You go ahead and say it. No, you're good.
Hello, Mr. Newman.
You have to.
Mr. Switek, on Mr. Newman's case, which is 22 CF 616.
Court will indulge me for this altogether.
Yes, sir. And Mr. Newman, I read through Mr. Switek's April 11th letter, the psychological evaluation. Also the letters from various folks, Wesley Sunday, there were numerous, Bart Allen, those letters. I looked at the plea and sentencing agreement, the state's April 5th letter, and then I have the score sheet. And I have pages 2 through 8 of the arrest report that has some of the quotes from the undercover officer and from you. Mr. Switek.
Thank you. Your Honor, did the court likewise review the report of Dr. Heather Holmes?
Yes, sir. Right. The psychological evaluation?
Yes.
Yes, sir.
A defense would move letters in the report into evidence.
No objection.
Okay. Madam Clerk, if you don't have those, you want those, I'll provide them to you.
I have the psychological evaluation,
But not the letter?
but not the letters.
Okay.
I think that what may have been attached to Melissa, give me 1 second.
Okay, good. She does have that. Yes, sir. So those are admitted.
Your Honor, in this case,
Mr. Switek, why don't you, if you're going to stay there, if you'll turn that mic toward you, so at least Court Smart will be able to hear
I
you.
might as well. Your Honor, in this case, State of Florida versus Taylor, Shane Newman, 22 CF 616. The defense is likewise going to ask for downward departure based on need for specialized treatment for a mental disorder. Would be the first argument. The second argument is that the offense was committed in an unsophisticated manner. It was an isolated incident, and the defendant has shown remorse. And these can be established by competent and substantial evidence. First off, I'd like to call Felicia Newman to the stand.
Ms. Newman, if you'll please come to the stand.
Do you swear or affirm that this testimony you must give will be the truth, the whole truth, and nothing but the truth?
Afternoon. Ma'am, would you please state and spell your name for the record?
Felicia Newman, FELICHIANNEWMAN.
Okay. I think we have some aircraft flying overhead. It's making it difficult to hear. If you can get a little bit closer to the microphone.
That better?
And bring it up a little bit to your face, that might help. Okay, let's try that. Are you related to Taylor Newman?
Yes, that's my son.
Okay, maybe try bringing it down. Yes, yeah. Okay. So Taylor Newman is your son, correct?
Yes.
And he's also referred to as Shane?
Yes.
And Shane is in fact his middle name, but he goes by that?
Yes, sir.
What can you tell the court about your son?
My son has never been in trouble until this. Prior to this, he's had a seatbelt violation.
Okay. Ms. Newman, I know this is going to be tough for you, but we've got to be able to understand what you're saying.
Sorry.
So if you can try to concentrate to slow down a bit.
Prior to this, the only thing he's ever had is a traffic violation, and that was seatbelt. I've not been a perfect mother. He hasn't had a difficult life. Prior, my first husband was abusive.
Can you describe that?
He was physically abusive to me in the beginning. And young and stupid, fear of failure to world, I guess. I stayed with him. I moved my son and all of us up to near Chicago, and the second he laid hands on my son is when I left.
And this was his biological father or stepfather?
No, this was his stepfather. His biological father has never been in the picture.
Okay.
His biological father was not the best of people, and I opted at that point that he didn't need to be in my son's life.
Okay. So you left that man. What was his name?
Thomas Farley.
Okay, and I think you still need to get on the microphone.
Oh, sorry, Thomas Farley.
Okay. And as far as Shane's upbringing after that, what happened?
After that, after I moved back down here, I dated and was with a few. I dated one guy for like 3.5 years. At that point, the guy just had nothing to do with him. Mentally checked out. So with me working 2 jobs, my son pretty much from the age of like, I moved back down here in from probably the age of 8 to probably 11. My son was pretty much raising himself at the home. There was an adult there, but as for a parental, not really, because I was working 2 jobs.
How many hours a week were you working?
I was working probably 80 hours a week, if not more.
And what were you doing?
At that time, I was working Sonic of a morning as a car hop for 40 hours, plus sometimes, and then I was working call center for a company called Great American Products over in Destin.
And what's Great American Products?
It was a vitamin company. Come to find out, it's probably a ripoff, but they were one of those vitamin companies that give you the free trial and then you're supposed to call and cancel before. So I started at the base and then eventually I was on escalations with that.
Okay. So you're struggling and you're essentially a single parent because the other guy's checked out.
Yes.
And were you getting any financial help from him?
From his, to begin with, yes, but then his father's company was found out that they weren't paying taxes and he was a framer, and the contractor decided that he no longer wanted to work with the company and he thought that it was $20 an hour or nothing. Okay. So for the first year, yes, of the 3.5 years I had some help. But after that, no.
So you're struggling. You're not making Elon Musk money.
None.
And because you're working 80 hours a week, it's difficult to bring up a child.
Very difficult.
Eventually, your family settled in Panama City, is that correct?
We eventually settled in Panama City. When I separated, we lost the townhome we were in. We were evicted, and I moved to Panama City and moved in with my ex-husband of 14 years. We were together 14 years. We were married 12. And he may have been there financially. As for a parent, I'm just thankful he doesn't have children of his own. He's very, very cup is half empty. Very
Sorry,
negative.
can you repeat that?
He's very cup is half empty, very non-emotional, just not parent material. But I figured at that point I had stepped up. At least I had some financial help with my son.
How did Shane do in school?
He was never a straight A student. He did have a learning disability. He had an IEP. And with that, it was basically, a lot of it was test anxiety, deadlines, timing. So they would give him extra time on his test. There was also some reading issues where, as for certain things that he read, didn't compute for testing issues, things like that.
So with the result of those tests, besides giving extra time for taking tests, did I say that clearly? The results of the IDP test, is that correct?
IEP.
IEP. Besides giving him additional time to take his regular classroom tests, was there any other plan put into place?
He did have some, all the way through high school, he did have a reading course that he'd done. Saving grace for high school, I feel, was his culinary. He got involved with Mr. Downs in high school. Arnold High had a culinary academy, which taught at a college level, but also taught them from ground up. And that's been his passion.
How many years did he study in the culinary field?
He did all 4 years in high school, and then he is, I think there's 2 or 3 classes he needs to get his culinary degree. After that, he has worked in several restaurants, including one of his professor's restaurants.
Okay. Which professor?
Chris Enfinger.
In which restaurant?
He worked for him under, Chris was part owner of Gulf Coast Burgers, and then he was owner of Bo's. It was a barbecue place, and my son at that point was head chef at Bo's.
Okay. And he's had other jobs in the culinary field, is that correct?
Yes, sir.
Do you know them?
He worked for a short time for J. Michael. That's a local seafood restaurant over in Panama City. He has also worked Carrabba's. He did work for Marcos also. He not only helped with making the pizzas, but he also did deliveries and stuff too.
Other than the delivery, though, with his primary employment in what they call the back of the house in the kitchen?
Yes, sir.
Besides yourself, what family ties does Shane have?
My parents are in Walton County, both my mother and my stepfather. My stepfather raised me as his own. His cousin and all of his family is in Walton County. He's closest to my dad's cousin, Steve Sunday, and his family, Joyce and Wesley. Him and Wesley are 3 years apart. They grew up just like brothers. And then there's my cousin that lives in Bay County. That's his godchild. That's his.
As far as a criminal history, I think you brought up that he had a seatbelt violation.
Yes, he was in the parking lot of Rocket Lanes and did not put on his seatbelt before he started moving. So the officer did stop him before he got out of the parking lot and gave him a ticket for no seatbelt.
Okay. Well, one of my appeals in Judge Maney's court was to appeal the constitutionality of the seatbelt law. I succeeded on other grounds.
Well, in his defense, with that ticket, my son was literally come home and wanted to pay the ticket right there. It was an instant, can I pay it now? Can I take courses? He was wanting to make it right. Because he realized, yes, I wasn't out on the road, but yes, I should have done it the proper way. So he was willing at that point to pay it, which granted, it took almost a month before Bay County got it in the system for him to pay it, but he wanted to pay it immediately. So he was trying to make it right, even something that little.
Has Shane talked to you about making this right?
Yes.
What has he shared with you?
One thing is he has talked about the counseling.
I'm sorry.
Sorry. He has talked about the counseling. We are looking into different ways of getting him into the counseling. He was seeing a counselor after seeing Mrs. Holmes. The counselor pretty much told him until this was over with, he didn't want to see him. So he did go, I think, 3 times before he told him that. And at that point, we couldn't get another counselor for him. So he is looking to do the counseling. It has been a big toll on him. But he is also, with his culinary background, one of the things he wants to do going forward is he wants to start his own food truck and eventually a restaurant, but he wants to do it as a second chance option for those first-time offenders, to help them get back on their feet.
Ms. Newman, those are the questions I have for you. Ms. Berickman, who's the Assistant State Attorney, you may have some.
I don't have anything, thank you.
Thank you, ma'am. You can sit down. Thank you for being here. Mr. Schweitzer?
Your Honor, I call Taylor Shane Newman to the stand.
Mr. Newman, if you'll please come to the stand. truth, the whole truth, and nothing but the truth, so help you God. Thank you, sir. Please be seated.
Are you good to go?
Best I can be.
Okay, I'll give you a couple of warm-up questions. I'll throw softballs to you to kind of get you going on this, okay? State your name.
My name is Taylor Shane Newman.
And would you spell that?
Taylor ShaneNewman.
Mr. Newman, where did you grow up?
As far as I can remember, I've spent most of my life in Florida. I did spend, I can't tell you exactly how long, but in Indiana, and came back down here for the rest of the time being.
Okay, did you say Indiana?
Yes.
Okay.
You would have to ask my mother exactly what city. I never could remember. I just knew it was around Chicago area. Or like we were like 45 minutes from Chicago.
Okay. So maybe like Fort Wayne.
I think, like I said, you'd have to ask her. I was young. At the time, I was just kind of basically following my mother. I didn't ask the city at that time.
Your mother has explained to the court that you had an abusive upbringing at the hands of your stepfathers.
Yes.
Is that correct?
Yes.
Can you describe that? What happened?
Well, as she said with Tom, Thomas, I called him Tom. He would get angry with her, and my room was down in the basement because we were living up north. You could actually have a basement than like down here, but he would come down, throw me out of the bed, and just drag me around. But we moved out shortly after that.
Okay, and you found yourself here or over in Panama City?
Well, we moved back to Freeport first, just so we can get back on our feet. We moved back in with our grandparents. Well, my grandparents, her parents. And then moved over to Panama City.
Okay. And where did you go to school when you were in Freeport?
I want to say it was free. I can't remember. It was like the Freeport Elementary School. I can't remember the name of it.
Okay. Well, that's a school in Freeport.
Yeah. I want to say I think it was Freeport Elementary. I could be wrong. I don't know.
All right, and in Panama City Beach, right?
Yes, I moved. I remember being in middle school in Panama City Beach. I went to Hutchinson, and then I went to J.R. Arnold High School.
Okay. And how'd you enjoy school?
I liked school once we stopped moving. But like once we were moving around, it was hard.
Okay. My mother taught school for 40 years, right, 30 of them right here in Okaloosa County. And she said the worst thing that can happen is getting a new child into your class. It takes a teacher at least a month to figure out where that child is academically. And then the child has to catch up. Is that what was happening with you?
Yes, I did unfortunately fail one grade from moving so much.
Could you repeat that? I'm having problems hearing.
Sorry. I did, since we were moving up until third grade, that's when we started stabilizing where we were at. I did fail third grade. But after that, I didn't fail another grade after that.
Okay. And then your mom said you got into the culinary program at Arnold?
I did, and in college as well.
And how'd you like that?
It gave me an actual drive to want to go to school.
Okay. And what college did you go to? Gulf Coast?
Gulf Coast, yes. I believe now it's a state college, I believe, if I remember right.
Gulf Coast State College?
Yes.
How far did you get?
About 2 to 3 classes from finishing. And it's just because I couldn't ever get into them because I couldn't get my counselor to register me in time for those classes.
And do you hope to finish?
If I can get out, like, I'm not saying walk away from this, but I would like, I've been out long enough now that I need to restart, in which honestly I think it would do me more good now to restart than just to finish.
And 3 classes, you can knock those out in a semester.
Exactly, but I feel like if I go back, I can hone my skills, maybe learn something I didn't learn the first time.
Your mother described some places that you worked with as being fast food. Is that the majority of your experience?
No, depends on what you consider fast food. Marco's, yes, that was technically, to me, my only fast food job. Carrabba's, most of the stuff I did was prep. I did get to the line. It wasn't very long, but I got to the line, and then they cut me due to budget cuts because winter came around and I lost my job at that point. But other than that, I haven't actually worked a fast food job.
We're going to jump to February 11th of 2022. And you have accepted responsibility and entered a plea to the bench, right?
Yes.
And why have you done that?
Because I believe the judge can give me the fairest judgment that is needed for this trial.
Okay. And you still believe that?
I still do.
The state has said that you had some bad conversations on February 11th, extending into February 12th. What are you accused of?
I'm accused of sending inappropriate text messages to a minor.
Okay. And did you follow up on those text messages?
No.
You didn't travel to see this person?
No.
There was discussion about exchanging pictures, right?
Yes, but because I'm one of those people, if I see your face, I can remember your name. And even over text messages, if I can't remember your name, I won't talk to you. It's just one of those, it's the only trust issue I have. It's one of those, I feel like I can read people more face to face than I can over a text message.
Did you ask this person who you thought was how old?
Well, after I found out they were 14, my intentions were still the same. I never wanted anything out of it besides friendship. And even then, once I found out I was 14, I still limited myself. I was mentally still said that I didn't want anything more than if they needed to talk to be there.
Okay. Isn't it true that there was conversation involving pictures and you told this person that you believed to be 14-year-old female, not to send you nude pictures?
Yes.
Why?
Because I do not want them.
So the extent of the conduct is the text messages.
Exactly.
On an application called Badoo, correct?
As far as, yeah. On my end, I didn't know it was called Babu. It was a different app on my side.
Okay. How does that work?
I'm not a computer person, but what I had on mine was a very old app, and I'm like got a match on it. It was my site was hot, and I never heard of this one called Bamboo. And when they came to talk to me about it, this one I was confused because they said that name and not the one that I knew.
I understand that on February 11th, you don't normally drink, right? Alcohol.
No.
But on February 11th, you did.
I did.
How much?
I can't honestly tell you. I remember at least 3 beers, and we did 2 rounds of shots, and after that, I don't really remember anything until the next morning.
Okay. When you say we,
I was out with 2 of my coworkers.
did you discuss these text messages or sending text messages to an underage person with your coworkers?
No, the only time I talk about women to my coworkers is the ones that I want them to meet.
Okay.
And I never was going to meet this person, so that person never would have met my friends.
Did you plan this with anybody?
No.
Had you ever done this before?
No.
Do you have a cell phone now?
I do.
Okay. If one of these law enforcement officers was to inspect your cell phone on there today, would they find any bad, inappropriate text messages?
What do you mean, just like you talking about nude photos, stuff like that?
I'm talking, would they find any conversations with you and an underage person?
Oh, no.
Okay.
Sorry, I didn't understand the question on that one.
Okay. Dr. Holmes states that you reported to her that you were at Chris's.
No.
Chris?
Chris is one I went out with. We were at Dave & Buster's.
Okay. And Chris's grandmother had just died.
Yes.
And y'all were there drinking beer and doing shots.
Well, he's one of those people, he's an alcoholic. He is now recovering because I finally got a hold of him. And he has stopped drinking. He's now a month and a half sober, but he's a self-destructive drunk if he drinks by himself.
Okay.
My goal was not to get drunk that night. It was just to have a beer so I could watch him to make sure he did nothing wrong.
Dr. Holmes also says that you told her, "I'm sorry, I can't even believe I did this." And she concluded that you were not denying your correspondence, but was rather surprised that you participated in the offense. Is that correct? Yes. Why is that? Why are you surprised?
Because I didn't think that was anything I would do.
Are you sorry you did it?
Yes.
What can you tell me about that?
That it was stupid. Should have never happened. And as soon as I heard the age, I should have just cut it off and just went my separate way.
Have you thought about the effect of this could have on a 14-year-old girl?
Yes.
And what's your conclusion there?
I believe if you are not mentally ready for it, it will make you grow up way too quickly. It will make you lose your childhood and make you do something stupid in the future.
Okay. So are you telling the court that you're not telling the court you're sorry for yourself, you're telling the court that you're sorry what your actions could do to somebody else, is that correct? Mr. Newman, those are the questions I have for you today. Ms. Burton may have some.
Ms. Burton?
I don't have anything.
Mr. Newman, let me ask you. Why did you put in your text to who you believe was a 14-year-old girl? Why did you put in the text about using your fingers?
That was a part of the night, honestly. I cannot tell you because I do not remember. Like, if I could remember it, I could honestly tell you a reason, but I do not remember sending anything more than just trying to be friends.
So you don't remember when you stated that you'd have sex with that person if they were comfortable with it?
No, because even with people that I've met and of art, like, that I talk to now, I've had women ask me to come over and have sex with them, and I'm still not comfortable with it. Like, to me, I have to have a connection with someone. Like, if I do not know you physically and mentally, by physically I mean I've seen you in person, not photos, anything like that. Like, if I have no connection, it's not that I fear people, it's just people make me uncomfortable.
Do either of the attorneys have any questions based on the court's question?
No, Your Honor.
Mr. Switek?
No, Your Honor.
Thank you, sir. You can step down. Mr. Switek, any other evidence?
No, Your Honor.
To the state, any evidence?
Just the offense report and checks that were submitted as part of the state's sentencing letter.
Any objection to those being?
There are no objections.
Okay, those are admitted. Mr. Switek, argument?
Your Honor, I'd start off with Dr. Holmes's report to the court. And on the last page, contrary to what the state has written in their sentencing memo, that my client is a danger to society, Ms. Holmes observes and states on dynamic measures he was deemed to fall into a low-risk category. He lacks the criteria to be considered a high risk for reoffense. However, his own history of trauma and his current level of anxiety, which predated the offense, required treatment. We would submit that a downward departure sentence based on the need for specialized treatment, as Dr. Holmes says, is in order for his general anxiety disorder, which he has tested for and diagnosed him with. We also move for downward departure based on the offense was unsophisticated, it was an isolated incident, and he's shown remorse. And I think we've presented competent, substantial evidence to that effect. Almost by its very nature, it's unsophisticated. He didn't travel, he didn't send pictures, he texted. Were the texts inappropriate? Yes. Were they illegal? Yes. They qualify as an offense. But it's not the same as going over to somebody's house and having sex with a minor. It's not the same as getting in a car and traveling to that house to have sex with a minor. it is, and I hate this expression, and when I hear it, it's like fingernails on the chalkboard. It is what it is. It is what it is. It's inappropriate text messages, but it's nothing else. It's wrong. It's wrongful. But it's not traveling, and it's not engaging in sex. It's engaging in inappropriate conversations that were illegal. Apparently, this is an isolated incident commencing on February 11th, and it's not clear from the offense report, from the incident report. What I read in between the lines is that it continued with a second conversation on February 12th, but I'm not exactly sure on that. But still, it's an isolated incident. It's a continual, short-term, probably less than 24-hour incident. It's not a string of burglaries to cars, and theft of a car down in South Florida, and this, that, and the other. It's a one-time offense. And you even said, today, look at his phone today, you're not going to find anything on it. And while he's been out on bond, certainly that could have been done as well, inspecting his phone. And if it had, I bet you there would be nothing else on it, because it's out of character. He did it most likely because he was intoxicated. His remorse is evidented by his demeanor, on the stand today, and the court can see how upset he was, and the court can see how sorry he was, as he testified to, and the court can certainly recognize that he recognizes that this offense was wrongful. And if it had been a 14-year-old girl, it could very well have been harmful. And he's demonstrated genuine remorse for that. And not one word did I hear, "I'm sorry for myself, I'm looking at prison." So we can judge him by his actions, certainly, but we can shape individualized sentencing as is appropriate, given the totality of the circumstances. His upbringing, the abuse he suffered, problems he's had in school, corrective measures that he's taken to be successful by getting involved in the culinary field and going to Culinary Arts Academy. And I would think that he would continue on with that. And, Your Honor, that's my argument for today.
Thank you. Ms. Barrett?
Judge, we're asking the court to adjudicate the defendant guilty and sentence him to 3 years in the Department of Corrections, followed by 2 years of sex offender probation. And I do want to correct, in our letter it said that the chatting began on February 10th. That was incorrect. It is February 11th. Mr. Switek was right about that. It's a little unclear in the chats.
Thank you.
This defendant contacted an undercover officer posing as a 14-year-old female on Badoo, Brooke. This took place both on Badoo and text messaging. In a brief review of the chats, the defendant was aware that this person was 14. And when asked if that was a problem, he responded, "That will depend on how far this goes." When it's brought up again, he says, "I don't care about age." When Brooke mentions nobody talks to her, he says, "Well, that's because you're underage." So he was well aware of how old she was at the time, or how old this undercover chatter was saying they were. Instead of ceasing conversation, he then asks if she has a Snapchat, and again, Brooke pushes him away. Later on, he asks where she's located and if it would be worth the drive. Would you be worth it? He says they'll have sex if she is comfortable, watch a movie if she is not. They discuss contraceptives, whether or not this Brooke could get pregnant. That's essentially the basis for the charges in this case. Court's well aware that downward departures are a two-step process. First, whether the court can depart, whether there's legally sufficient evidence presented by defense to depart, and secondly, whether the court should. Defense has asked for downward departure on several bases today. The first is that the defendant qualifies based on specialized treatment for a mental disorder unrelated to substance abuse or addiction, and that the defendant is amenable to that treatment. The first prong of that analysis is the existence of a mental health diagnosis. And Heather Holmes said the defendant has been diagnosed with generalized anxiety disorder. That is the diagnosis she gives. We would note the defendant denied ever taking any medications for psychological reasons or being prescribed them, never having any previous mental or psychological ailments, and he's denied ever seeing a psychiatrist, psychologist, or counselor for any issues. Dr. Holmes' mental status exam notes that he reported feelings of anxiety, but attributed them to the charges pending against him. Essentially, these symptoms seem to stem from his current legal issues. So state would submit that is not something he previously suffered from. It's directly related to the pending charges. Defense must also demonstrate the need for specialized treatment unrelated to substance abuse. As to the specialized treatment prong, Dr. Holmes makes the following recommendations: individual therapy for childhood trauma and anxiety, and abstinence from alcohol. The state would submit that that is not specialized treatment. Individual therapy for trauma and anxiety is widespread and common. And also concerning to the state is the statement from Dr. Holmes that the driving force behind the behavior was his lack of intimate relationships due to his anxiety and his alcohol consumption. So secondly, importantly, to receive a downward departure on this basis, it must be unrelated to substance abuse. And while the defendant reported only drinking rarely, he then also claimed he was drinking heavily and doesn't recall this last exchange that led to the arrest. And in review of the messages, the defendant says he was bored and drunk on February 12, 2022, which he said just means my standard, I believe he meant standards, and morals are low. When you drink, nothing is off the table. That is concerning. And that is not unrelated to substance abuse. Lastly, defense must show that the defendant is amenable to treatment. We don't believe we even get to that prong of the analysis. However, in review of the report by Dr. Holmes, I don't see anything within the four corners of that document regarding amenability or the likelihood of his behavior changing should he comply with the recommendations. We would also note that amenability is not mere statements by the defendant regarding their willingness to engage in treatment. So we don't believe defense has met their burden to show all three prongs of that test for downward departure. The second basis submitted by defense today is that the offense was committed in an unsophisticated manner, that it was an isolated incident for which he has shown remorse. The first element is that the offenses were committed in an unsophisticated manner. And the court in Bellamy held that they should consider whether there were several distinctive and deliberate steps taken to commit the offense, as well as whether the defendant expressed concern or acknowledged the illegal nature of his actions and had an opportunity to reflect on this and or walking away. That's 199 Southern 3rd 480. There were a number of deliberate steps taken to commit this offense. It took place over time and over two mediums, video and texts. The defendant had to reach out to law enforcement posing as the undercover to initiate the conversation. In review of the chats, the defendant is the one who reinitiates a lot of the conversation. And each time he reached out to send another message, he took another step. And I know the court has had a chance to review those. And there's a number of messages there. So this was an ongoing offense. He had plenty of time to think about what he was doing and his actions. As to whether he expressed any concern or acknowledged the illegal nature of his actions, he does acknowledge what he's doing is wrong. He says, "You put me in jail for 15 years. When asked what for, his response was sex with a minor, grooming, and later said, sadly, nothing happens to the minor. That shows he's aware of the nature and the consequence of his actions, and yet he chose to continue to chat. So it appears his actions were not unsophisticated or isolated. It's also been mentioned today that it might be isolated due to his lack of any criminal history. However, lack of criminal history has been specifically held by the Florida courts to be an invalid non-statutory mitigator to justify downward departure under State v. Goggin. That's 27 Southern 3rd 111. The third element defense must prove for downward departure on this basis is that the defendant has shown remorse. And we would leave remorse to the court's discretion, but we would note that under State v. Bleckinger, 746 Southern 2nd 552, a simple "I'm sorry" or cursory apology is insufficient. We don't believe defense has met all three prongs, that it was unsophisticated, isolated, and that the defendant has shown remorse in order to qualify for downward departure on that basis. Defense also mentioned Heather Holmes' report findings that indicate she believes he's a moderate risk to reoffend on one test and a low risk to reoffend on another. But frankly, that's not a recognized basis for downward departure with the Florida courts. There are also mentions that the defendant has strong family and community support, and I know we heard from his mother today. But again, the fact that the defendant has strong support from his family has been specifically held by the Florida courts to be an invalid non-statutory mitigator to justify a downward departure under State v. Chestnut, 718 Southern 2nd 312, and State v. Goggin, which I previously referenced. Therefore, we don't believe defense has met their burden to downward depart on any basis. However, if the court believes the defendant qualifies for downward departure, its second analysis is whether it should. And the state submits in this case it should not. The primary purpose of criminal courts is not to rehabilitate the defendant, it's to protect the public and hold the defendant accountable for his actions. And we've heard a lot about Mr. Newman today, but in review of the actions that brought him before the court today, the sexual solicitation of a 14-year-old named Brooke, that is what we're asking the court to review in sentencing him in this particular case. And defense had submitted, of course, he didn't travel to meet a minor, there was no child pornography on his phone. Certainly there wasn't. If that was the case, he would be here on other charges instead of a solicitation. And while it was fortunate it was an undercover officer in this particular case at the other end of the line, the legislature created that specific language in the statutes, allowing law enforcement to engage in this type of work to protect children from being victimized as a protective cautionary measure. So for these reasons, we're asking the court to sentence the defendant to 3 years in the Department of Corrections, followed by 2 years of sex offender probation and the conditions previously outlined in our letter.
Thank you, ma'am. Mr. Schweitek, anything further?
I don't agree with the state with their observation or conclusion that this young man's use of alcohol disqualifies him from a downward departure sentence. When I was a younger person, I drank. And sometimes I drank often, but I was not an alcoholic. I was not somebody who abused alcohol. And that's what the state is portraying that this case involves. No, that's not what this case involves. The testimony that's been presented and the evidence that has been presented is that he has used alcohol just probably no more, no less than any other young person. Not that he was an alcoholic, not that he needed to go to rehab or anything along those grounds. Like many young people, he overused alcohol on February 11th and was intoxicated. That does not disqualify him from downward departure. If he was a continuing alcoholic or a continuing drug addict, then we could say, all right, treatment for those two things should not be considered when granting the downward departure. But we're not saying that he needs to to seek treatment for those things. We're saying that he needs to seek treatment for the general anxiety disorder that Heather Holmes has diagnosed him with. And Heather Holmes made the observation, oh, by the way, don't drink, it causes you to do stupid things. And that's what her observation was. As far as the three-pronged analysis, if it had been a series of events, more than one conversation with one person over a period of time, then we could say that it was not isolated. If he had a prior record, an extensive prior record of that, we could say it's not isolated. And there have been cases that I'm aware of where one offense or two offenses from a period of time back would not disqualify on the isolated offense problem. So I believe we're on solid ground on that. We're on solid ground that he has shown remorse and he understands the consequences of his actions and how they could affect somebody. But for one incident, I mean, this is exactly why we have these mitigators, and they're codified by statute. For one incident, to send this young man away for 42 months or some other period of time, followed by 5 years of sex offender probation, is just wrong.
Thank you, Mr. Switek. Mr. Newman, I have, a lot of emotions, a lot of feelings about the case, but I have to follow the law. I can't ask you to follow the law if I won't follow it. So I grabbed my big old bench book because there were different things that were said about alcoholism and different things like that. And I was like, wait a minute, let's see exactly what the statute says. So I look at that. The defendant requires specialized treatment for a mental disorder that is unrelated to substance abuse. So either the unrelated to substance abuse relates to the treatment is needed and the treatment is unrelated to substance abuse, or the mental disorder is unrelated to substance abuse, which in your case, both of those are true. So you qualify for that. And that you're amenable to treatment. Watching your demeanor, watching you testify, reading the history, everything that's happened to you in the past, the court finds that you fulfill both of those requirements. Then looking at the other possible reason for a downward departure. The offense was committed in an unsophisticated manner. Years ago, I looked up, there's a case called Atkinson, it was still a Florida Law Weekly at the time. That was, I'm sure, when I wrote it down. 36 Florida Law Weekly D 579, and I wrote down artless, simple, and unrefined. But you understand the two different mediums. One an application, another text. I understand the different statements that were made that the state brought up about, if I get caught, I'm going to go to jail for 15 years. I mean, those are huge things that when I was doing my homework, just reading through the paperwork, a thought that I had and I wrote down was, no question, sentence to everything state seeks. So those were my thoughts coming on the bench, without the benefit of everything here, without argument, without really delving into it as deeply as we have today. So unsophisticated manner, I do find that that is fulfilled. It was an isolated incident. It was interesting, the 10th versus the 11th and the 13th. I do find that it was an isolated incident. I do find remorse. So you fulfill those requirements. So the court can downwardly depart. But should the court downwardly depart? Again, the language in the text gets a lot of traction with the court. You didn't use the word alcoholic blackout, but that's basically what comes across to the court is you were drinking and you can't remember what you did during that time. You actually put it in one of the texts. I've been drinking, that's why I can say these different things. So I understand that. That's not a defense. If it was, I'd hear that all the time. But that, in conjunction with your upbringing, with the situation that you grew up with the trauma that you've had in your background, the court does find that it should downwardly depart. So you were sentenced to 5 years sex offender probation. You'll be placed on a GPS monitor for that 5 years. You're designated as a sex offender. You'll need to complete sex offender treatment, provide a DNA sample, comply with all statutory registration requirements, have no contact with minors, have no electronic equipment or computers with internet connection capability. And when I say that, talk to Mr. Switek about ways that may be tweaked in the future under your culinary, if you need that for your work, if you need different things like that, that can be a thing that you can come back to the court and modify it for work purposes. Okay? And I really hope that you'll follow that. That's an art.
But for right now, he can have a dumb phone.
Correct.
A flip
Yes,
phone.
Correct. Any devices that were seized are forfeited. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. There's a $40 per month cost of supervision. Curfew from 7 p.m. to 6 a.m. However, probation can adjust that based upon your work schedule. There's also a $217.48 cost of transportation to the Okaloosa County Sheriff's Office. You will need to, if I didn't state it, you'll need to abstain from alcohol during your probation. You'll need to submit to random breath tests. You'll also need to undergo individual therapy for your history of childhood trauma and anxiety, and take any medications that are prescribed. Okay. You do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
I do.
Thank you, sir.
So I did not hear you. Did you say adjudicated?
He's adjudicated guilty, yes, ma'am, as a sexual offender. Yes,
Your Honor, probation, no objection, transferable to Bay County.
absolutely no objection to that. Okay, thank you.
Does Your Honor have a score sheet?
Everything's concurrent, yes, ma'am. Yes, ma'am,
Okay.
thank you. I do have a score sheet.
England.
Thank you. Thank you for a long day at work. Court is adjourned.
Thank you, Judge.
Tough case. I'm glad you and not me. Let me unplug this and I hear you.
Thank you.
There were good things starting up.
What's that?
No, this is pre-trial, this is live stream probation.
But thank you. What? I'll try to pay that in mind.
Back to normal. I just sum it up. All it was yes. So we were come back tomorrow morning to be fully instructed, and then we will transfer your case. So here's our address right here. They're expected to be, so go ahead and go on.
But beyond that, that's all we've got.
He needs to bring the court everything for that. Well, that is a
See you later, bud.
It has nothing to do with us, and you'll eventually have to give that back to the trial. So who takes it off to the county? That will be pre-trial.
Yeah.
So you'll end up with two right now, and then we'll have to give it to that pre-trial that will
Are you on my phone?
You'll have to call the pre-trial.
I'll see you next time. Be down there.
The other one is
Ron?
okay?
One more
And
thing.
then head over there.
Can we get GPS at $1 a day?
Yes, sir.
Tomorrow morning, they'll get in more. Yes.
You know, talking to them, I gotta go to bed. I'm just messing, you can go ahead. I'm making sure I have everything.
Oh. Hey.
That's special for this.
No. Thank you.
Good. Other than just.
Well, Okaloosa hasn't expanded into the knock unit, so it's more than enough. There's many of us right now.
No.
Luckily, it's just mostly OCS, so it does a lot of travel. Thank you very much. Definitely. Thanks for staying, Ken.
See me back.
Appreciate it.
Luckily, Mondays are
I know she, her and probation emailed me, though, this is it. Yes. I'm really pretty sure that there's not another one. This is it. It's just, you know, there's no felony case, it's just.
It's so funny. She's driving to Atlanta right now. She's doing a triathlon this weekend.
And I'm thinking she's blind.
Apparently.